daughters are having equal right as of son. So this phrase in co-personary property, daughters are having equal right as son, is considered as the declaratory statute. Till the declaration, the act was silent. Due to that amendment, some new declaration is made. So this is called declaratory statute. If you look into the slide, the third kind is remedial, and I would also like to discuss with remedial statute the amending statute. The remedial statute is the statute which provides remedies for violation of any kind of right. For example, Security Exchange Board of India Act. This act was silent, was not providing any kind of provisions to set off the case after the impugned order of this particular authority as set by SEBI. Till the year of 1992. After the Amendment Act passed in SEBI Act in the year of 2000, dear friend, the separate authority was established. In short, it is known as SAT, but the full form is Security Appellate Tribunal. This SAT, Security Appellate Tribunal, is set to set off the order passed by the authority already established under SEBI Act. So this amendment set out a new remedial authority named Security Appellate Tribunal. So this particular amendment or the law enacted by the Parliament is known as remedial statute, which provides also for the remedies. Amending statute means as and when if a new act is passed, it will amend the previous one. The best example is very recently the Finance Act is passed by Indian Parliament, which is known as the budgetary provisions. Every year Finance Act is passed in the Parliament, which amends the provision of Income Tax Act 1961. So it is called, the Finance Act particularly is the example of amending statute. Now the next kind of a statute is consolidating statute. For this, the best example is as written Central Excise Act 1944. Before 1944, there were almost 17 to 19 commodities which are separately, each commodities were separately levied excise duties on those 17 different commodities. So these different 17 commodities were collected together in one statute to levy excise duty. This particular collection or consolidation is titled as the Central Excise Act 1944. So it is nothing but the consolidation of various things which are here and there they are lying. Instead of lying everywhere, these provisions are consolidated in one statute, becomes the Consolidated Act or Consolidated Statute. The next kind of a statute is the Enabling Statute. With Enabling Statute, I would like to discuss the Disabling Statute. Enabling Statute, which means the statute which enables the new thing. Foreign Exchange Management Act, FEMA. Up till now, it was silent on foreign direct investment in particular sectors. In short, it is known as FDI. Nowadays, it is a very current issue and burning issue. Up till now, FEMA was silent on foreign direct investment in some sectors. But due to the amendment, now FEMA also allows foreign direct investment in some sectors. So, this amendment is the statute falls under this category. Enabling statute, the statute which enables the new things. FEMA. The disabling statute means, for example, in this same issue, if you imagine that FEMA was previously allowing the foreign direct investment in particular sectors, but due to the amendment, that particular enabled provisions were deleted from the act. So that new amendment is known as disabling statute. Some provisions are disabled from its use. And the last is penal statute. Penal statute means the statute which provides for the offense or for the violation of the statute, the provisions, as well as the punishment for that violation. The example is Indian Penal Code itself. These are the main 8 statutes which are having direct relation with the interpretation of statute. How one should understood the meaning of the statute is known as the interpretation. Whatever is written in the statute, when that written words are explained by someone, that explanation is considered as the interpretation of statute. Dear friend, this is the normal definition or the meaning of interpretation. But as I have stated earlier, there must be some legality in each and every definition when one is discussing a law. Here, the meaning of interpretation is very fine and very well defined by two knowledgeable authors of legal jurisprudence. They are Samand and Cooley. First, I will discuss the definition of interpretation as discussed by Samand. If you look into the slide, Samand says interpretation is a process by which the courts seek to ascertain the meaning of the legislature through the medium of authoritative forms in which it is expressed. Interpretation is a process by which the court seeks to ascertain the meaning of the legislature. Not all legislature, but legislature through the medium of authoritative forms. This particular definition contains two main parts. One is interpretation is a process. It is continued process. It is not by one. If he interprets the provision, the process is end. No. This is the continuous process by which court seeks the ascertainment of whatever is written by the legislature. You just remember, if you remember the definition of Maxwell, will of the legislature. Whatever is written by legislature, when that written words are ascertained by the court. Not every written word, only those words which are passed by the legislature. This phrase is written at the end of this definition by the phrase authoritative form in which it is expressed. So, whenever a statute is passed, if that bill has not acquired the title of a statute, the court will not even try to interpret the provision of a bill. Court will definitely say, we are not authorized to interpret the provision or the matters included in a bill. Court can interpret only the law which is passed by the legislature. So, court is applying the act, court is applying the statute. If court wants to express the other than the statute, it is not the part of interpretation. Clear? The first definition, it is a process, and the second thing is court ascertains whatever is being written by the legislature through the medium of the authoritative mode of the legislature. The second definition as given by Cooley is interpretation is an art of finding out the true sense of any form of words, that is, the sense which their author intended to convey. Here, the second definition is very simple, that interpretation makes it clear what is the mind when the author has written. Intention of the author, if it is made clear, it is known as interpretation as defined by Cooley. So, Cooley defines interpretation as it is the process of finding out whatever is written in the document which was in the mind of the author. So, this is the second definition of the interpretation. So, we have discussed what is statute and what is interpretation. Now, let us discuss the objects of interpretation. Dear friend, as the object of interpretation is nothing but to make clear what is the meaning of the phrases or the document passed by the legislature, namely Parliament. But this object, if we want to serialize it, it can be serialized like this. The object of the interpretation, as per the Halsbury's laws of England, as our law is, the source of Indian law is in England, the Halsbury's law says that the object of all interpretation of a written documents is to discover the intention of the author, as said by Cooley, is to discover the intention of the author, the written declaration of whose mind the document is always considered to be. So, the object of interpretation is to discover the intention. Intention of whom? Intention of the author who has written this document. If this author is legislature, it is the statute. So, it is to discover the intention of the legislature. What is the meaning of that document? This is the first object as said by the Halsbury's Law of England. The second object of interpretation is prescribed or discussed by the court in the case of Seaford Court Estates Limited versus Asher. It is the judgment of 1949 to KB King's Bench, page number 481. KB denotes King's Bench, and the judgment observed by Sir Danning L.J. He observed that it is not within human powers to foresee the manifold sets of facts which may arise, even if it were. So it says that the object of interpretation is to see what is being written by the enactor. He observed first, it is to foresee the intention of the legislature, what they wanted to explain. Further, the Sir Danning observed that it is not possible to provide for them in terms free from all ambiguity. He also emphasized on the English language, rather on language. The English language is not an instrument of mathematical precision. English is a language, or anything which is explained of statute, they must be explained in any language. Language differs from man to man. It is not like the mathematics rule that if you do the sum of 1 plus 1, the answer will remain same.